Under Article 2, Section 718, Subsection 1 of the Uniform Commercial Code, or UCC, parties to a contract for the sale of goods may agree to a reasonable liquidated damages clause. In judging whether such a clause is reasonable, courts consider three things. First, the anticipated or actual harm caused by the breach. Second, the difficulties of proof of loss. And third, the difficulty of otherwise obtaining an adequate remedy. In California and Hawaiian Sugar Company versus Sunship Incorporated, the Ninth Circuit considered whether a liquidated damages clause between two parties was enforceable under the UCC. California and Hawaiian Sugar Company, which we'll call C&H, was an agricultural cooperative owned by 14 sugar plantations in Hawaii. Part of C&H's business involved transporting raw sugar from sugar plantations in Hawaii to a refinery in California. In 1979, C&H's main shipper stated it would no longer ship the sugar beginning in January of 1981. As a result, C&H commissioned the building of a hybrid tugboat and barge. After soliciting offers, C&H contracted with Sunship to construct a barge and with Halter to build a tugboat. As to the contract between C&H and Halter, Halter agreed to deliver the tugboat to Sunship on April 30, 1981. And as to the contract between C&H and Sunship, Sunship agreed to deliver the finished vessel to C&H on June 30, 1981. The contract price between C&H and Sunship was $25,405. In addition, the contract stated that if the vessel wasn't delivered on time, Sunship would pay, quote, as per day liquidated damages and not as a penalty, unquote, $17,000. Further, it stated that the amount was a reasonable measure of the damages. The contract was negotiated by high-level managers and under advice of counsel. Sunship was late with performance and finished on March 16, 1982. Halter was also late and finished on July 15, 1982. The vessel was delivered shortly afterward, but on January 10, 1982, after roughly 6 months of payments, Sunship stopped paying under the liquidated damages clause and denied liability. Subsequently, C&H sued Sunship in federal district court for breach of contract, seeking money owed under the liquidated damages clause. Following a hearing, the court found for C&H. Sunship appealed to the Ninth Circuit.